Thank you for giving me this opportunity to share my learnings on medical negligence. Medical negligence is defined as a breach of duty owed by a doctor towards his or her patient to exercise reasonable degree of skill and care. While negligence is a tort or a civil wrong, medical negligence are also mostly of civil in nature. However, some of them may amount to criminal negligence as well. Medical negligence is considered as the unintentional commission or omission of any act that a reasonably prudent doctor, medical professional, would do or would not do under certain given circumstances. For example, administration of a wrong medicine, administering high doses of medicines like heparin or some critical drugs, removing of the wrong body part, surgical operation of the wrong eye, etc. Acts of omission could be such as failure to do a basic diagnostic test or failure to provide follow-up treatment after an abnormal test report, failure in appropriate post-operative care after any surgery, even failure to obtain informed consent from a patient who is undergoing a planned and elective surgery is considered as negligence because it amounts to infringement of basic human right. And this human right is that of one's own autonomy and right of self-determination and informed decision making in his or her own treatment. And this was strongly laid down in the landmark case of Samira Kohli versus Dr. Prabha Manchanda. For medical negligence to be proven, certain elements have to be established by the plaintiff, the first one being a duty of care. That's the doctor-patient relationship, which, as per the Consumer Protection Act, has been stated to be one of a contract for service. There is a duty of care. And that involves expected standard of care, duty to provide timely care by qualified and competent medical professionals, and other duties which are created by the applicable laws related to healthcare. The second element being the breach of duty. Third, the consequential damage. It could be physical or mental suffering, implications of death and expenditure because of the medical complications, loss of earnings, so on and so forth. The fourth most important element being the causation or the proximate cause, which requires a reasonable, close and causal connection between the negligent conduct and the resulting injury or the damage. The courts have time and again applied the Boehm's test in proving medical negligence cases. There are various others important landmark decisions. The Supreme Court in Paschim Bengal case Mazdoor Samiti and others versus State of West Bengal, or the Parmanand Katara versus Union of India, has given guidelines on emergency life-saving treatment which needs to be provided by hospitals and the duty of doctors in such circumstances. The patients, the consumers today reach out to the consumer courts and medical councils to seek civil remedies. The Consumer Protection Act of 2019 has enhanced the interest and the consumer rights. Today, an aggrieved patient can file a case in their own district Consumer Disputes Redressal Commission, and because it's based on the amount of consideration that they have paid while availing the medical service, and it's not anymore on the quantum of compensation that they claim. The Consumer Protection Act of 2019 also brought out an important concept of product liability, wherein the biomedical equipment manufacturers of drugs and consumables have been made liable for faulty or defective equipments or faulty drugs which has resulted in injuries to the patients. In cases of gross negligence and in death cases, we have seen criminal cases being filed against doctors under Section 304A and various other sections of the Indian Penal Code, which is currently the Section 106 of the Bharatiya Nyaya Samhita 2023. However, it is important to understand the landmark judgment of Jacob Matthews versus State of Punjab, where the Supreme Court, the Apex Court, has framed guidelines which govern the prosecution of doctors for such offences of criminal rashness or negligence, and that the investigating officer has a duty to obtain independent and unbiased medical opinion from a competent board. So there is clear-cut distinction between cognizable cases and registration of FIR in the regular criminal cases and that of medical negligence cases. Thus, I would like to conclude that medical malpractice suits can be prevented by good and trustworthy doctor-patient relationship and the medical professionals upholding the principles of medical ethics, which is beneficence, non-maleficence, autonomy, and justice, that is treating all patients equally. Finally, I would like to mention that, as always, the legal profession, by its inherent nature, has focused on knowledge sharing and teamwork amongst legal colleagues in its endeavor for timely rendering of justice. And today I wish Vakil Paathashala in this new endeavor of learning and development towards the legal professionals. Namaskar.